Good morning or good afternoon to where you are joining us from today. My name is Dan Johnson. I'm the Director of Marketing and Customer Experience here at myHRcounsel. I wanted to thank all of you for taking the time to join us today, and a special thank you to those who have joined one of our webinars before. Before we get started, as a reminder, this webinar is being recorded, so if you need to jump off, that webinar will be saved and you can watch again later. And then we will also send a follow-up email tomorrow. That email is going to include the recording, the slide deck, as well as the HRCI and the SHRM recertification credit codes. If you have any questions about the material this presentation, please open a ticket in our Ask an Attorney portal, and we would be happy to provide a legally backed answer to your specific question. If you would like to learn more about our subscriptions, please contact us at info@myHRcounsel.com. And now I'd like to introduce today's presenter, Britt Waterman, who's a senior attorney here at myHRcounsel. Thank you, Britt.
Hi, thanks, Dan. So today we're going to talk more about background screening tips. This is a topic that's kind of become a hot topic lately, or unfortunately come to the forefront of a lot of employers' minds based on some recent issues, things we've seen in the news. A lot of companies starting to think more about background screening, but it's something that you can't just dive right into. It's something that you want to do correctly and with legal compliance. And so I'm here to talk to you today about ways that you can do background screening and still comply with the federal and state law. So our overview today are the four kind of areas we will discuss. What is background screening? Why do employers screen? Like I said, the kind of the unfortunate recent events is becoming a bigger reason. What are the compliance requirements? What is laid out in the law? The parameters that you cannot stray from, and kind of best practices for background screening and some of the frequently asked questions that we get about background screening. So what is background screening? When we talk about background screening, we generally talk about pre-employment screening. This usually isn't something that occurs during employment, although it certainly can. It usually doesn't occur during employment because you can be at risk of a discrimination issue if you are screening certain employees and not others during employment, although certainly if you have a valid non-discriminatory business reason for screening one particular employee during employment and not others, it's not out of the question. But mainly we're talking about pre-employment screening, and this is a service that has to be job related, and the information has to be legally obtained on your job applicants, and you're looking at both public and private information about both the applicant's qualifications and about their behaviors. So both kind of they're looking at what they put on their application and is it correct, and also some of their conduct, their past conduct that may be predictive of future conduct. And employers are concerned about multiple things, about risk. Like I said, about some of the risks with regard to violence and crime, risk as far as honesty when you're dealing with financial information or personal identifiable information, things that would be of a sensitive nature. Employers are concerned about having someone who would be honest, who would not be at a high risk of misusing that information. So those would be factors that would need further consideration where you would bring in a background screen to get more information about, looking at this person's history. Do they have a record of committing crimes of dishonesty or losing a license, being disqualified from performing certain kinds of work? Is that would maybe a sign that this person is untrustworthy, or that they may be at higher risk to be around a certain population. So these are the things that background screening looks for, and why it's used. So there are many things that you can obtain through background screening. It's not just, I think most employers just think of it as a criminal background check, but there is much more you can find out other than a criminal record. You can verify past employment and educational achievement. You can do credit reports. You can get a driving record or a motor vehicle report. You can check professional licensing, and again, that would include not just professional as in attorneys or physicians, but certified nursing assistants, or other licensing, such as that, or someone who runs a home daycare and is licensed to do that, someone who has a cosmetology license, any type of license where they could face discipline for failing to comply with professional standards. You can check licensing for compliance and see if someone has had their license taken away. There's other public information that is sometimes part of the background screen that either an employer can find doing an in-house background screening or using an agency that would be checking public information such as the sex offender registry, which is public. Anyone can check it. You can look up anyone's name on the sex offender registry. Civil records, and like I said, disbarment or sanctions against an attorney or a physician, any civil records, any civil action that someone be involved in, someone suing someone else for a breach of contract or negligence or any civil court. And then there are social media searches that can also be part of background screening. So the pitfalls of background screening, these are areas that can get you in trouble before you even start with background screening. So failing to follow state-specific laws. We'll explain more about state and federal laws coming up in a little bit here, but there are certain laws, ban the box and fair chance are names for specific types of laws. State laws regarding the parameters of background checks. Credit history is something that's regulated by state laws. The FCRA is sort of the federal law overarching over background screening. A lot of times background check reports contains personally identifiable information, private information that must be kept confidential. It must be kept away from everyone except the hiring manager or human resources. If this information is not protected by you, there's a high risk of an invasion of privacy claim. Even the application for the background check has PII in it and also protected class information. Usually when they fill out the application for the background check, they put their date of birth on it. As we know, age 40 and over is a protected class. So you've got that date of birth there on the application, and you must only use this protected class information for the purposes of obtaining the background check report, not for making any employment decisions. So if possible, only HR should see these applications that get filled out for the background check screening, or a hiring manager, but it certainly shouldn't ever be a frontline supervisor that ever sees any of this information. It should never go beyond a hiring manager or human resources. Again, why do employers screen? And I'm going back to some of the reasons, and you can see here. So reducing workplace violence, again, is the big one that has kind of been on people's minds lately. You can be sued for negligent hiring, retention, promotion, supervision if you hire somebody and they commit a crime or harm someone or do damage to property while they are your employee, and the person who is harmed or has their property damaged can sue you and say, well, you should have done a background check, because then you would have found out that this person has a propensity to punch people in the face or destroy speedboats or whatever the thing was that they would have done. And that could be negligent hiring. You could be negligent in hiring this person who has a propensity for doing whatever the terrible thing was, and you would have found out about it if you had simply done a background check. So you could be negligent by not screening that person, and it could result in liability on you. One big thing is prevent time wasted in recruiting, hiring, and training the wrong person. Obviously, that's a big investment in your workforce, is the recruiting, hiring, training, onboarding process, and you want to avoid wasting that time on the wrong hire if at all possible. There are some state and federal laws working with financial information, working with vulnerable adults or children that require background checks. You want to make an informed decision in accordance with those particular laws. Identify falsehoods about past employment or education. That can be very important. If they lie about that, what else will they lie about? Again, the lower turnover rate, you're increasing the quality of your hires, and that's going to save you money in the long run. So those are just some of the reasons why employers would screen. Compliance requirements. Again, the federal law, state and local law, the timing during the hiring process. So this would be the ban the box requirement, as many people have heard of. This applies to the timing during the hiring process. So every state is different. Some states have no laws regarding background checks, and it's the Wild West. Go ahead and ask about criminal history whenever you like, put it on your job applications. In other states, they say, well, not on the job applications, but once you call for an interview, go ahead and ask about criminal history. Some states say no, not until you've extended an offer. That's all going to depend on state law, at what point during the hiring process you can ask. Before, during, and after the background check process, what your obligations are during those specific periods during the background check process. There's no limit on employer size for these laws for federal and state and local law to apply to you. When it comes to background checks, you don't get a pass for being a small employer and kind of going freestyle because you don't have that many employees. Everybody does have to comply with these laws. You have to make a difference on whether you're going to conduct an in-house background check or hire a third-party CRA. We'll get to those. Each of those is going to bring up a new set of compliance requirements. So in-house background check, this is a background check that you would conduct without employing a third-party service or without employing a consumer reporting agency. This is, you may think, hey, we're going to save a lot of money by not hiring one of these fancy agencies. This could cost you a lot more than the cost of employing a legally backed background screening service. This could end up in a lawsuit, and you could be wishing that you had spent the money to use a service. Things that can turn up during an in-house background check. You can see photos. When you see photos, you can clearly see an individual's sex, race, gender. A lot of times when you are looking up, if you're doing in-house background checks and you're looking at Facebook, or you're searching up college yearbooks, things like that, you can see whether or not they have a membership in an organization with a racial or ethnic or religious affiliation. Again, that's a protected class. Now you have this protected class information. You can usually see, if you're looking at Facebook or Instagram, you can see their marital status, you can see their sexual orientation, sometimes you can see their age. Well, now you've got all this protected class information, and you're going to make a hiring decision. And how do you know that this, if you do not hire this applicant, how do you know that they're not going to come back and say, well, they didn't hire me because of my race, and I can prove that they knew my race because they were looking at my Facebook page? Well, what defense do you have to stand behind at that point? Other public records can be incomplete, outdated, inaccurate. If you're going to the courthouse and trying to look up criminal records by yourself, you're just going to find a lot of stuff that is not up to date, and a lot of misinformation there when you're looking on your own without an attorney. Other things that you can find, Colorado, California, Louisiana, New York, North Dakota prohibit employers from firing, retaliating, refusing to hire employees for off-duty lawful activity, including speech. Of course, you do not have to hire someone whose speech violates your harassment policy. So you don't have to hire someone who's got hate speech on their Facebook profile, but you could have someone who has political speech on their Facebook profile that is completely legal, or you could have pictures of them engaging, or participating at some kind of rally or protest, and that could be a lawful activity. And you may think, well, that kind of doesn't fit with our company culture, but you can't discriminate. And this is stuff you're going to find when you have in-house background checks. And now here you've got the information. How do you not discriminate? 30 states have lawful off-duty conduct laws when you include tobacco and alcohol use laws and marijuana use laws in Illinois, New Jersey, and New York. That means if you don't hire somebody because they have a picture on Facebook of them drinking a giant margarita or doing a bong hit in 3 of these states, and you say, yeah, we don't like that, we don't want to hire somebody who does that, and that this person finds out that that's why you didn't hire them, they may actually have a claim against you. So, and also misusing the information that you find on your own when you're looking this all up on your own and kind of having the information all spread out on someone's desk. You could wind up with an invasion of privacy, a defamation claim. You could be violating federal background check claims by doing this on your own. So in-house background check, you could face an intrusion on seclusion claim. This is something where employees have successfully sued employers for gathering non-work related personal information about them. You can get, like I said, an invasion of privacy claim for publishing private facts. You still may need consent, even if you're doing this in-house background check on your own. An example is in Georgia, you can do a criminal records search using the Georgia Crime Information Center Council. You can get criminal history records that are public in Georgia, but only with the employee's consent or fingerprints. So this is, and you must inform the employee and the applicant of all the information surrounding the decision that you got on the record. It's very complicated, even though you are using a public system doing public records, and failing to provide the information you got to the applicant can result in criminal charges, civil charges, penalties against you. This is very complicated and can get you in a lot of hot water just by trying to go to the public provider of criminal information in Georgia and thinking, hey, this is public information, I can get this myself. It can backfire on you immensely. And negligent disclosure, you could end up with a fine, you could end up with imprisonment for disclosing information that you find. California doesn't let you ask about or consider certain marijuana-related crimes. They don't let you consider misdemeanors more than 2 years old or detentions that don't result in convictions. If you go searching on your own, you might uncover a marijuana-related crime. You might uncover a misdemeanor more than 2 years old, and like they say, you can't get the toothpaste back in the tube. Once you know about it, then you have information that you shouldn't have, and you're stuck with it. So we can go to the next slide. So consumer reporting agencies, or CRA, this is the third party that you would use instead of doing the background check yourself. And this is a consumer, they would give you a consumer report. A consumer report is any written, oral, or other communication of any information by a consumer reporting agency bearing on a consumer's credit worthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living, which is used or expected to be used or collected in whole or in part for the purpose of serving as a factor in establishing the consumer's eligibility for credit or insurance, to be used primarily for personal, family, or household purposes, employment purposes, or any other purpose authorized. So this is the CRA can collect any of this information, credit worthiness, mode of living, general reputation, for employment purposes. The CRAs are regulated by the Fair Credit Reporting Act, which is a federal law, and they have to follow certain rules. The CRA, they are a regulated business, and they follow federal laws. Next, we can talk about the Fair Credit Reporting Act, this federal law. So this is, they promote fair and accurate credit and other types of reporting done by these CRAs. So it imposes requirements on employers as well. The FCRA, they establish requirements for the CRAs, but they also impose requirements on employers who use CRA. So if you use a CRA, the FCRA is going to have rules for you about disclosure, consent, and notifying applicants of pre-adverse and adverse action. Now this comes up, I see this a lot with when you have a staffing agency or a recruiter, and you have a third party who wants you to share the credit and consumer reports that you get from your CRA. When you get the reports from your CRA, those are yours. Do not share them with a third party. If your client wants to see them, tell your client no. So there was a temporary staffing agency in Massachusetts that obtained consumer reports on their temporary associates from CRAs, and the client company said, well, we need to see them. We need to see the background checks that you ran on your associates before we'll allow you to place them with us. And the temporary staffing agency said, sounds legit. Here's all our background checks. Well, the appeals court found that by passing on these consumer reports, the temporary staffing agency was regularly engaging in the practice of assembling or evaluating consumer credit information for the purpose of furnishing consumer reports to third parties. What that means is that the temporary staffing agency just made itself a CRA. So now, not only does the temporary staffing agency have to abide by the requirements for employers, the temporary staffing agency is now a CRA and has to follow the FCRA rules for a CRA, for a consumer reporting agency. So let me tell you, you as an employer, you're not prepared to comply with the requirements for a consumer reporting agency. So that's you're not set up to do these things. So unless you want to be fined for violating federal law, do not pass a consumer report or a background check along to someone else and inadvertently make yourself a CRA. Don't do that. So before conducting a background check with CRA, you must inform the applicant or the individual that you may be requesting a report. At this stage, you must do these requirements for disclosure. You must give a summary of your rights under the FCRA at each stage of the process. You can get this summary of your rights from your CRA, usually with the background check documents. They'll give you a copy of this. Otherwise, Google it. You can get it at consumerfinance.gov. That's the website, federal website for the FCRA. Consumer reports versus investigative consumer reports. You have to tell the employee in your disclosure if you're doing investigative consumer reports. Consumer reports are just the written, oral, or other communications that say we're asking about your credit standing, your character, your reputation, credit reports, criminal records, driving records. If you are obtaining investigative consumer reports are obtained through personal interviews with those who are acquainted with you or may have knowledge of any relevant information about you. If you are going to be conducting personal interviews with individuals to get more information, that does have to be in the disclosure. Most employers don't do that, don't go that far. Consequences of failing to provide the disclosure, McDonald's paid out a $950,000 settlement for running checks on 2,500 employers without providing that disclosure. So you're going to want to provide that disclosure. That's important. Authorization, this goes with disclosure like peanut butter and jelly. These are two things that you give together. They should not be on the same page. These should be two separate pages. One page is disclosure, one page is authorization. You hand these two pages to your applicant before you go any further with the background check. So you have to provide the disclosure and you have to get the authorization. Now, Domino's Pizza paid out a $2.5 million settlement. Publix grocery chain paid out a $6.8 million settlement for non-compliant authorization. Well, what's a non-compliant authorization? A non-compliant authorization would be essentially a click wrap authorization as part of your onboarding paperwork. You cannot have your applicants authorize a liability waiver on the same page as the background check authorization. You cannot have them do anything else on the same page as the background check authorization. The authorization must be in writing, it must be separate and applicable only to the background check. You cannot list anything else on the page and have them check an I agree box to anything else. That's not valid. They should only authorize one thing on that page. It should be the background check. It should not be an onboarding, an online onboarding set of paperwork where you click next, next, next to move on through the onboarding online paperwork. This should be, it can be an electronic paperwork, but they should have to provide an electronic signature. This should not be just a click wrap document in your onboarding paperwork. This is disclosure and authorization are two very important pieces of information that must be used. So what happens when something comes up in the background check and you don't like it? Before you can make an employment decision on the basis of what you see, the FCRA requires you to comply with the pre-adverse action requirements, which means you have to notify the individual and provide a copy of the consumer report, and again, provide the summary of the rights. Like I said, you have to do that at every stage of the process. So you have to set a waiting period. So the reason for the waiting period in the pre-adverse action process, sometimes the information that will show up on a background check is wrong due to identity theft. Some people have a relative or acquaintance that every time the police show up and pull them over or bring them in, that relative or acquaintance gives your applicant's name and date of birth to the police. It happens more times, more often than you think this would happen. So your applicant may actually have a letter from the Bureau of Criminal Apprehension explaining that the criminal record does not belong to your applicant. It belongs to Mr. Alias relative or acquaintance over here. There are other examples of identity theft. Of course, we hear about it all the time, stealing individuals' social security numbers, date of birth, driver's license number, and then, opening credit cards or ringing up debt or committing crimes. So this can happen to your applicant, and the reason you give the pre-adverse action notice and set a waiting period is if this background check truly doesn't apply to the person applying for the job, you need to let them come forward with the proof and say, hey, this isn't me, and this is how I can show you that it isn't me. In a fair, unless you are in a fair chance jurisdiction, unless you are in California or another area that has a fair chance law, you do not have to allow evidence of mitigation or rehabilitation in that waiting period. So you don't need to, during the waiting period, you don't need to allow someone to come and bring information that says, yeah, I was a bad person when I committed that crime, but now I have found religion and I'm a good person, I wouldn't do that again. You don't need to allow that to come in during the waiting period unless you're in a fair chance jurisdiction. But if you do allow this for one applicant, you must allow it for all applicants. If you are going to do that and allow applicants to provide evidence of mitigation or rehabilitation, you're going to want to work with counsel. So open a ticket if you are one of our clients. If you are not one of our clients, please email info@myHRcounsel.com to learn more about how we can help you do this. You need to set, if you're going to allow evidence of rehabilitation or mitigation, you are going to want to set up a policy to make sure you are doing that consistently and not having a disparate impact on any specific group or protected class. So the adverse action is what happens after you close that waiting period, after the pre-adverse action, and you say, you know what, nothing changed our minds. They didn't prove that it wasn't them, and this is what you must do when you make an adverse action, when you make the decision not to hire, or like I said, if it's someone who's a current employee, if you make the decision to terminate, a little less common. But you do need to provide all of the pieces of information that are listed here on the slide. Again, there's that summary of rights. Again, every stage you've got to provide that, and your background check company should have a copy of that. Otherwise, like I said, you can find that online. But you do need to provide some notices to the individual here about the CRA and their right to contest the results. So when you give the adverse action, there is a list here of items that must be in that letter or that notice. And if you do not have all of these things in that letter or notice, you are not compliant, and you're looking at one of these big dollar settlements that I mentioned earlier. So again, getting to the big dollar settlements, the pre-adverse and the adverse action process. Again, these may seem like a no-brainer, like a given. Hey, these applicants for employment know that they burglarized 3 houses 2 years ago and went to prison. They know why we're not hiring them. Why do we need to send them all these letters with all this information? Can't they figure it out on their own? Well, no. You do have to send the summary of rights from the FCRA at every stage of the process. If you do not give that summary of rights 3 times, you have to give that same document out. If you do not give that same document out 3 times, you are not following the procedure. You have to make sure that everything that was documented on the previous 2 slides is on the pre-adverse and the adverse action notice, which includes things like the name and address of the CRA, the background check screening company that you used. You have to have a statement saying that the CRA or the background check company is not responsible, that they did not make the decision for the adverse action. If you leave that one sentence out, you are not compliant. So if you leave, we looked at the previous 2 slides, and you'll get the deck in an email, so you'll be able to go through and again, look at each item by itself. If you leave one of those items out, if you leave one of those items out, you're failing to follow the procedure under the FCRA. Uber paid out a $7.5 million settlement for failing to follow this process. Lowe's, $2.2 million settlement. Dish Network, $1.75 million settlement by failing to provide that disclosure. The disclosure according to the requirements of what needs to be on it and how it needs to be that separate piece of paper, separate from anything else, and not part of a click-through in your onboarding paperwork, and failing to follow the pre-adverse adverse action requirements. Swift Transportation paid out a $4.4 million settlement for failing to advise applicants that they could access and contest their background check reports. Now, that when we looked at the past slide and I said, here's what has to be on the adverse action notice, and I had, just like here, little bullet points with the check mark, and one of them was, and it listed what needs to be on your adverse action letter, and there was one bullet point. If you were scanning through, you might have missed it, but one of the bullet points was, you have to tell the applicant in your letter that they could access a copy of their background check, and they could contest it with the CRA. That's one sentence you need to have in there. Swift Transportation left that sentence off their adverse action letter, and they were out $4.4 million. So that's we're not playing around with the FCRA. You need to look at the pre-adverse and the adverse action requirements and see what you have to do, and you have to follow those. Criminal background checks, state laws. So there's a patchwork of state laws regulating, like I spoke of before, when and if you can request criminal history information, what types of records can be sought, how old they can be. North Carolina and Oklahoma require you to distribute a state-specific notice saying you can request a security freeze of your credit report. Oklahoma, Minnesota, some other states, the authorization that you sign require you to have a box to check to request a free copy of the credit report, and you as the employer must make sure they get a copy. Different states have different requirements for certain occupations. Like I said, working with children, working with the elderly, taxi drivers, security system installers. Massachusetts requires employers to set up an account with their system called iCorey, and they have to give account access to their CRA for certain occupations. So that differs completely from other states. If you are in a fair chance jurisdiction, so a fair chance is different than just a ban the box law or just a more simple law. This is more complicated. Again, this is California and some other jurisdictions. So if you're in a fair chance state, you must when you do a pre-adverse action notice, you must do a written individualized assessment of how the conviction relates to the position sought. It has to relate. I have seen employers stretch like silly putty trying to get the conviction to relate to the position sought. You need to be reasonable here. So you send this with how the conviction relates to the position sought. You send this with the pre-adverse action notice. You have to allow the applicant to present any evidence of mitigation, rehabilitation, explanation. Like I said, in states that aren't fair chance acts, you don't have to do that when there is a fair chance act. You do have to allow that to be sent in during the waiting period. Then you have to do a written individualized reassessment explaining how you considered the additional information, how that relates to the position sought, how the age and seriousness of the conviction and the totality of criminal history is considered, and you have to send that reassessment along when you send that adverse action notice. So when there is a fair chance act, you really have to be on top of it as far as how that conviction is going to relate to the job, and you have to consider you cannot just say, well, they were convicted of burglary and it was when they were 16 and now they're an adult and they were using drugs when they committed the crime and now they're sober and they were hanging out with a gang and now they've got a completely different group of people. And they won't be handling any money or having any keys to anything or access to any property during this job. But burglary, we only want clean records. Not going to happen. With a Fair Chance Act, you've got to consider all of that information and how that is going to apply to the position sought and the mitigation and the circumstances and how all of that affects the criminal charge in the relation to the position. So a Fair Chance Act is going to completely shatter your fantasy of having a roster of employees with squeaky clean backgrounds across the board. The Fair Chance Act is not going to let you have that. You are going to have to end up hiring some individuals with criminal records, and you are going to have to really give a lot of thought to the hiring process when it comes to criminal background. And the EEOC recommends using the fair chance process when you are considering arrests. In many jurisdictions, you cannot consider an arrest that do not lead to a conviction. In some states and jurisdictions, you are allowed to consider arrests that do not lead to a conviction. The EEOC recommends that if you are in a state that does let you consider an arrest that did not lead to a conviction, the EEOC would like you to use a fair chance process when you are considering an arrest that did not lead to a conviction. The EEOC would like you to take a look at the arrest and think about how it applies to the conviction and whether there has been any mitigation or rehabilitation since the person was arrested, whether there were any circumstances surrounding the arrest that maybe made them less culpable. The EEOC would like to see you use the Fair Chance Act. So if you are in a state that allows you to consider arrests that did not lead to convictions, and this is not all states, but if you are in one of the states that does allow you to do this, do not just throw out anyone who's arrested across the board. Do what the EEOC says and use that process. Credit checks. Federal and state law does regulate credit checks. The FCRA is the main law on governing credit checks, but at least 10 states have mini FCRAs that place further limitations on credit checks. There are exceptions to the prohibitions. Vermont prohibits inquiries or about or adverse action based on credit histories unless the position is with a financial institution, a police officer, firefighter, EMT, if the employee has access to payroll, if the employee is going to have a fiduciary relationship, issue payments, collect debts, transfer money, enter into contracts. So you can see how it's all going to come down to state. Again, this is why you need counsel. This is why you need to open a ticket or please explore some of our packages at myHRcounsel.com and see how we can provide solutions for you if you are unsure about your state, if you need to see what the law is in your state. So states have these mini FCRAs that say, no, you can't consider credit information, but there are exceptions where you can. This is just going to differ from state to state. Federal law prohibits bankruptcies that are more than 7 years old, civil suits and judgments more than 7 years old. You cannot consider those. You can't use an applicant's in some states and cities using a credit report to make an employment decision. Drug testing, not exactly background checks, but I just wanted to touch on it because just like background checks with drug testing, it's not the Wild West out here. Drug testing requires authorization and disclosure exactly like a background check. Just like I said, two separate pieces of paper and exactly no click wrap, no click through, no click next for drug testing. It should always be done in accordance with an established policy. Applicants should get that policy, even though they're just applicants and they don't get your handbook, they should get the policy. Some states, Minnesota, Arizona, Iowa, Maryland, just for examples, have unique specific policies that must be written and followed. Other states say, hey, as long as you've got a drug testing policy, you're good. Some states don't even require that. You know, there are a lot of state-specific issues with drug testing. Nevada prohibits refusal to hire based on a positive marijuana test. New York City and Philadelphia won't let you test for THC at all. One thing we're seeing with a lot of employers is that they are ordering the full panel drug test, and they're asking the testing company, you know what, just don't even report THC. Just we don't even want to know. In some states we can't consider it. We can't use a THC test in making a hiring decision. You know, it's legal in our state, just or there's protections. Just forget about reporting that. Getting set up with a lab and just going to town is not going to be enough. The lab knows how to comply with the law on their part. They generally don't care whether you're complying with the law on your part. So check with counsel. We've got authorization and disclosure forms that you can use. The lab might have some that they give you to use, but if they don't match your handbook, they're essentially useless. So best practices, be aware of your legal responsibilities before, during, and after the background check. Know the advantages of using a legally backed background check company instead of doing this in-house, instead of doing this just kind of freestyle by yourself. And ask before you act. Open a ticket. Ask info at myHRcounsel.com if you have any questions about becoming a myHRcounsel client, and being able to ask those important questions about background checks and avoid those costly mistakes. And the best practices, again, know your responsibilities under state and local law, have a uniform process for compliance, having a uniform process and doing everything equally, consistently, fairly. I can't stress that enough. Treating everyone the same, every applicant the same is so important. Keeping the consumer reports or background check reports in a confidential file that is not the personnel file and retaining them for 5 years. And when it is time to destroy those after the 5-year mark, to get rid of those background check reports, shredding, burning, rendering electronic files unreadable and unable to be constructed, you want to get rid of them. You want to make sure that they are gone and cannot be reconstituted. And make sure you're complying with the FCRA. And again, ask counsel if you have any questions about how to comply with that. We're here to get you through every step of the way. What could go wrong? Again, I scared you with those big numbers with some of those lawsuits. And again, those big numbers come from damages, punitive damages, attorney's fees, court costs. Damages before punitive damages, and punitive damages was what made the other lawsuits go up in the millions there. So damages are capped at $1,000 per violation, but I guarantee you, when one applicant makes a complaint and they discover one violation, they're going to come in and check you out. And one violation is going to lead to the discovery of multiple violations. I guarantee you, you didn't mess up just one time and that lucky applicant happened to find it. If you've been doing it wrong, you've been doing it wrong. That's going to add up for you. And this is beginning to be what's called a yacht case for class action attorneys, meaning this is with judgments in the millions. This is what allows these class action attorneys to purchase their yachts. So don't let somebody buy a yacht on your back. Follow the FCRA. We've got 5 minutes left here. Frequently asked questions. Is it true we can't find out about crimes an applicant committed more than seven years ago? The FCRA will let you go back on a criminal record 10 years. Some states do have a 7-year limitation. Again, if they're on the sex offender registry and they have to be on that for life, that's public, and you can find out about that. But yeah, the Consumer Reporting Agency is only going to be able to bring back information about crimes for 10 years or 7 years in states that have the 7-year requirement. We are a staffing firm, and our clients demand to see background checks on our employees before they will hire them. What can we do? Again, touched on that. Don't make yourself a CRA. What can we do? Attestation. You can tell your clients, we will attest that our associates that we send to you meet your background requirements. We will swear on a stack of Bibles that the clients that the associates we are sending you meet the background check requirements that you gave us. We will sign a promise and get it notarized, but you cannot see the background check results themselves. Frequently asked question, we hired someone way before we got the background check results back. Now they've been hired and they worked a couple weeks and we found out they've been convicted of murder. What can we do? What can you do? You can get a time machine and go back and not hire this person before their background check comes back. Please don't let them start working before the background check results come back in. This is just going to create trouble for you. What can you do? You can terminate this person if they're an at-will employment. If you've signed them up for an employment contract, you're in a different set of circumstances. If they're an at-will employee, to terminate them. But let that be a reminder to you that you should not let someone start working before the background check results come back. The position we're hiring for requires driving. Can we find out if our candidates have ever been arrested for DWI? Yes, you can. You can do criminal background checks. You can do motor vehicle record checks as well. I'd like to pre-screen candidates and not move forward with those who have a record. Can I do that? That depends on what state you are in. In some states, yes. In some states, absolutely not. No way can you do that. Big trouble if you do that. It's just going to matter on the state. That's why you need to check with counsel. Do I have to background check all my candidates or just those who raise a red flag in the interview? If you background check one, you must background check all. You cannot pick and choose. That is going to cause big discrimination problems for you. If you background check one, you background check all of them, not just those who raise a red flag in the interview, because I guarantee that red flag is going to turn into a green flag with a $sign on it for someone in a protected class who is saying that they were background checked when a number of people who are not in that protected class were not background checked. That is a bad thing to do. You're discriminating and you're going to pay for that if you do it. So we're right here at time. If you have any questions, please open a ticket. We'd love to help you comply with the law on background checks. If you're not a ticket, excuse me, if you're not a client, you can find more resources at myHRcounsel.com. You can certainly send an email to info@myHRcounsel.com. We'd be happy to share more about our packages or help get you signed up so that you can open a ticket so that we can provide answers to all of your background check compliance questions and also provide expert legal advice from licensed employment law attorneys to all of your HR and employment law questions.
Thanks again, Britt, and thank you everyone for attending our webinar today. As promised, we will be sending out that follow-up email tomorrow. That's going to have the slide deck, it's going to have the recording, and it's also going to have the HRCI and SHRM credit codes as well. And thank you and have a great rest of your day.